Good morning, everybody, and welcome to the 49th episode of Cannabusiness Live from the Cannabis Legal Group. I'm Craig Aronoff.
Travis Copenhaver.
Welcome to our show. Got a nice agenda for today. Hopefully we'll get lots of people to help us out, ask some questions, like us, share us, find us on YouTube. You'll find our link down below, and our other 48 shows are available there. Today we're going to be talking about the update to the emergency set of rules. We're also going to be discussing yesterday's board meeting and the decisions of the board to both grant and approve licenses, as well as those that unfortunately were denied their opportunities and their pre-eligibility. So, big agenda. We look forward to any questions, comments. We got a lot to talk about, so we invite all of them. So today, let's start us off in, some of the information that we got from the board meeting, I think could kind of set the table for the conversation. What did they give us as far as a summary of where we're at in the application process? And then we'll kind of talk about Rule 19, and then we'll kind of get back into it.
All right, perfect. So according to Laura, there are 546 filed and paid applications in the state system right now. Of those, some of them are far enough along where they can determine and have data on the number of different types of licenses being pursued. There are a total of 92 grower licenses, about 10 Class A's, 3 Class B's, and 79 Class C applicants. There are 28 processor applicants, 81 provisioning center applicants, 6 secure transporter applicants, and 5 safety compliance facility applicants. Laura also let us know that as far as they're aware, they have a number of around 96 municipalities that have participated and they're receiving applications from.
So a lot has happened.
A lot.
Not much.
Exactly.
Yeah, and so while we're all frustrated and we all share, good morning, Wendy, and while we share, that frustration with everybody else, I think it's important to recognize that, Laura's doing what it can. It's understaffed. Right. It's teaching their staff how to do this work. My understanding is I think they have 14 full-time analysts going right now, and they're all working at what the state will allow. So, if it's 40-hour weeks, that's all we got. And so, we'll see, I think, activity pick up. We got another meeting of the board here in, 10 days, I think it is, on the 11th. And then several more over the summer before the June 15th removal to September 15th now. Please, again, while we want to be frustrated, let's continue to be patient. We are seeing activity.
If you look at it on the whole, this is new for the state of Michigan. There are a lot of moving pieces. There are parts of it that we can, dive into, criticize, be frustrated with. But there are other parts of this overall machine that are being done very well. So we should, as much as we are concerned about things we see, we should also, be positive about the things that are going well. And there are a lot of good people there doing a very hard job, learning something for the first time the same way everyone in the industry is doing this for the first time and coming into a new program. And as that new program is rolling out, there's going to be some speed bumps and hurdles along the way. But the state of Michigan, in my opinion, overall, is doing a fairly good job.
Yeah, I mean, and while we might have our criticism and our constructive thoughts for them, what we don't want to do is just continue to pile on. I mean, that being said, we do have a lot of thoughts about, a few things that have come up. But before we get into the board meeting, and Wendy, you're asking to talk about the CBD debacle as well, we'll be happy to talk about that throughout today's show. Kind of fits the profile of the discussion, which was really, the board meeting. That'll be the meat and potatoes, but there was a very important thing that happened on the 30th. The board, Laura itself, actually got a new set of rules that it extended. We knew that the original temporary emergency rules were set to expire June 4th, so they got ahead of it by nearly a week. And in so doing, they corrected the timeline that we're fighting on Rule 19, as well as some safety compliance information that was previously in Bolton. So let's get into Rule 19. What was the substantive change? And then how does that affect clients and those that are seeking operating licenses?
Definitely. So Rule 19 is the rule that allows operators to operate temporarily. What it does effectively is if you were in a location that either had previous marijuana local ordinances in place or passed an ordinance before December 15th for the MMFLA specifically, and you got some sort of local approval from your municipality, you had the ability to submit your state license to LARA before February 15th. And if you were able to do all those things, you're allowed to operate temporarily under Rule 19. Rule 19 effectively allows you to continue your operations while the state determines whether or not you should get your final license. And the deadline for that operation was, until very recently, June 15th.
In fact, the deadline was for LARA to issue its decision on your application by June 15th. And so the reason that most, if not, well, actually all of our temporary operating entities right now haven't actually, met that deadline is specifically on LARA, and so while everyone is doing their best to do and act in good faith, which is a requirement under the rule that you're acting in good faith throughout this whole process, meaning you're filing things timely, you're responding to LARA, you're truly being the applicant you're claiming to be. That requirement now is giving us more time. So this 92-day extension is really not only for the operating entities, but most importantly for LARA to finish its business for you.
Right. And if you're a stickler for the details, in Rule 19 under Section 5, the very first sentence says, the department effectively shall either issue a license or deny an application. There's no real middle ground there. Now, granted, this is an emergency rule, and there are a lot of parts. The administration part of LARA can't, make the board's decision for them. The board needs to do its job. The administrators need to do their job. Inspections need to incur, deficiencies need to be answered. So just because that's what was supposed to happen didn't mean that in reality, how this is all going, that was a likely,
Well, I think that, first of all, we all know that no Phase 2s have actually been even before the board, let alone approved by the board. I guess within the rumor mill, and we'll push it out there that maybe we'll see some by June 11th, but that remains to be seen. We are aware of a number of temporary operating facilities that have been inspected by LARA, that have done Phase 2 activity. We know from the board that there's, the numbers that Travis quoted before, dozens of, Phase 2 applications at the state level. So we're going to start to see it, and the metrics of that will come out. And as we discuss the metrics of the pre-qual, the metrics of Phase 2 will start to show us some of their responses and how LARA is going through what it means to inspect and how the board is being reported on, because that doesn't seem to line up in Phase 1 right now.
Right. And something other that's also very important to note about Rule 19 is if you are in one of these municipalities that had some sort of previous marijuana ordinance that didn't actually contemplate the MMFLA, June 15th was also a deadline for those municipalities to pass a new ordinance authorizing this conduct under the statutory structure of the MMFLA. And some prominent locations where temporary operators were, like the city of Detroit, for example, have yet to do that. So even if LARA does its job, even if the applicant does its job, the municipality has a role to play as well. If they have temporary operators within their community and they don't have that new ordinance contemplating the requirements of the MMFLA, well, that doesn't matter. That you need to be authorized by your local municipality under the statute. So that gives local communities a little more time to do their job as well.
Yeah, and it's kind of the necessary evil to it all right now is that the state just simply needed more time, communities needed more time. What's frustrating is having the leverage of a deadline, we would have hoped to have seen more activity. We would have hoped to have seen some of these communities whose ordinances aren't fully in play that do have temporary operators actually take the steps necessary to keep those operations going, but for this extension. That didn't happen, but we do see that this extension exists. So I think, now maybe the precedent is set to say that depending upon what our numbers look like in September, there might even be, additional timelines that could be considered, depending upon how our patient population is serviced. If they've only gotten 4 or 5 dispensaries around the state done by September, clearly that's not enough provisioning centers to meet the patient population in demand. So maybe we'll see some differences. One cautionary tale, and this is something Travis and I were talking about before too, is the way temporary Rule 19 is written. It really writes, paragraph 1, it says that as applicant for a state operating license may temporarily operate a proposed marijuana facility that would otherwise require a state license.
That's the key right there. If you read Rule 19, Section 1, if you're operating a facility that would otherwise require a state operating license, That's what Rule 19 is about. A caregiver, for example, that system has not gone away. 2008 is in place. Caregivers and patients can operate legally pursuant to the rules that have always been in place for the last 9 years. But if there's conduct that would otherwise require a license, Rule 19 requires you to go through these procedures. So it puts temporary operators in a position that raises a lot of questions. Well, how are you going to operate in a way that requires a license when you don't have all the other factors that the whole system of the MMFLA brings to the table? How do you transfer products to patients? If you're a caregiver, you can do so through the caregiver system.
How do you even sell if you're growing and you've actually have a harvest? You have nobody to sell that product to. It's not tested yet. It's not secure transport.
How do you move it from your facility to someone who wants to sell it?
I mean, you're not acting like a caregiver anymore if you're above the 72 plan requirement. And so our statement here is caution.
Right.
And be very cautious. Just because you were given the authority locally to temporarily operate, pay attention to how you're operating within both the MMMA and the MMFLA, because we're going to start to see how the board reacts to you later.
Right. Maybe as early as the
next week, right? Yeah. So again, our advice remains to be cautious. We'd rather err on the side of risk aversion. Why give up what could be, a whole career in the cannabis space for a few $1,000s during this window of time that you're going to get set up? Be smart. Use your time wisely during this. And that takes us to the board itself. So let's kind of pivot to yesterday's meeting. And Scott, thanks for the question. We'll get to a response to you in just a moment or two. But I think that because it will get into this. There was some communication yesterday that was very troubling from the board. There were some positives I think that came out of it, and definitely some advice that we can offer. So let's just, from a high level, why don't we give kind of a summary of what happened.
From a big picture, some of the known factors have been applying again. The biggest factors for applications that were denied yesterday were for disclosure issues. Applicants failed to disclose some information that was read into as problematic, and that was a big factor for a lot of those denials.
Disclosures are huge, and we're seeing that time and again. We'll get into that deeper, but keep going.
So, but beyond that, we did start to see some character and fitness determinations leading to some of the ways those board members were voting yesterday. For example, applicants that would otherwise technically qualify under the rules, there was some factual information that called into question whether or not the board was comfortable in, and then when I say the board, I mean specific board members were comfortable in approving or denying those applications. And I think some of the discussion around that, or in some cases lack thereof of discussion, causes some concerns for applicants or future applicants about how this is all going to work.
Yeah, and I think that as we look at it from a summary level, without the specific discussions, it is concerning because there's a whole appeal process through this emergency rules that say if you are denied, you have the opportunity to go before a hearing panel that will, allow you to pitch your case, and the board has the obligation to prove what the denial was. And so, there was no factual development. We as attorneys like to have the precedent. We like to have the facts, and then we can make argument based upon the facts. Quite frankly, the report very well might have, that was given to this board, very well might have outlined exactly what the hearing itself would prove.
Right.
And at what point were they going to actually listen to the report from Lara? Then again, there might have been language in that report that could have caused and raised this. But it seemed like a lot of the concerns, these quote-unquote presumptions that we saw yesterday, really were like out of left field.
Yeah, something to keep in mind, and just as a way of caveat while we get into the weeds here, but we do not have access to what is before the board on paper for their considerations. When they're asking questions, when they're having a discussion, they are discussing things from a position that we as observers don't get to see. So when they have a report from Lara, when they are talking about the issues they're concerned about, if they don't actually state on the record what those are, we don't get to see the full story. But even regardless of that, the way the board members voted in different ways regarding those conversations, we don't see a lot of those factors being discussed. For example, a lot of these denials are based on what ultimately is considered knowingly submitting false information. That's what a disclosure problem technically renders your application problematic.
Yeah.
If something should have been in that application and it wasn't, and the board considers you as to have knowingly withheld that information, then that is an appropriate denial.
Yeah, and where that comes from is in Section 402 within the MMFLA is where the license board is given its authority in Section 1 of, or 401. Section 402 is where it specifies things like if you have a felony that's, less than 10 years old, you're not eligible to apply. So this is where that criteria is set, and for purposes of making a proper record, you heard them go back yesterday, and when they wanted to deny it, have to put a statutory reason behind it. And the paragraph that Travis is referencing in 2C uses this word knowingly false, and so knowingly means you intended to make a false statement, that you that there was actual malice or design, or something greater than oops, I didn't mean to do it.
If this were a criminal trial, it's what we call mens rea. It's your state of mind. I'm no criminal attorney. We should get Barton in here for this, but effectively it's this: did you purposely do something? Did you knowingly do something? Did you recklessly do something, or did you negligently do something? Right. And that's the level of scrutiny down to the factors. It didn't say, should you have known, but you didn't. I mean, that's not knowingly. Knowingly, to me, as an attorney, means I knew I should have done this, but something about me thinking it would be problematic didn't. Yeah. Not, this charge is 30 years old, I was a kid, I don't maybe remember what technically was happening.
So we do have, and this allows us to talk about an earlier denial where somebody had failed to disclose something from the early 80s as well, and that person's response to Laura when asked, why didn't you disclose it? Their answer was, I didn't think you'd find it. That to me means, and I can probably split the hair and make a legal argument on the other side, but I can justify the argument that says, if you didn't think they'd find it, that means you knew that it was there and you chose not to share it. That's a problem. That's knowingly misleading. That's the right hook. Right. What we saw yesterday was them assume that the person must have known for themselves why they left it off, as opposed to maybe the explanation that was provided in that report indicating that it was done unintentionally and by accident, yet the board still assumed a knowing proposition, and I think that we need to sort that out.
And there are at least some cases where we could assume that was not what was happening. In theory, there could have been something on paper that would add context to why the statement was being presented that way. But when you saw other board members calling into question the assumptions other board members were making, it doesn't seem likely to me.
Yeah, it wasn't. It must not have been in that record. And I'll quote Chairman Johnson, who actually made the quote of, "I don't remember anything from 1981, and I was a farmer." Right. And I take that language to be meaningful. I mean, if that's somebody on that board could readily admit that they might not readily remember everything from, it's now 40-something years ago or whatever, or 30-something, whatever it is. That I think should give us as operators, us as applicants, the same opportunity to say, I simply don't remember what I was doing exactly then, and I inadvertently forgot to share that.
Now, let's be realistic, though. Right. If you were in jail for 5 years or you were busted in a major crime, it's very unlikely that you failed to remember that.
You're being asked to remember that.
Exactly. So let's not throw all caution to the wind here and be like, I just didn't remember. Prove that I didn't. I mean, there's some context that's very important. The difference between a minor possession charge and being busted for 4,000 plants in Minnesota are very different types of conversations to have. And that's another reference to something that was discussed yesterday, but it's a little different from this knowing conversation. But for example, if you were in college and you got picked up by the cops because you had a couple grams of marijuana on you, and you went to court and you did some probation, if you were a kid, you might not really know if that technically was a conviction or not if you weren't paying attention, or it happened a long time ago. Or if you went through the 7411 process and it's off your record and it hasn't affected your life for the last 25 years.
Yeah, I mean, I think it's, as we get into how to clean up applications, first of all, we don't want to be in a position where any client has knowingly failed to disclose it. When anything comes up on the IFCOM, we're doing our best to dig down deep and learn as much as we can, but also provide an explanation on day one about why certain information might not be known. It's not likely that conviction from 81 has any record available in any court or anywhere. So even if they did their best to disclose and figure out dates and times and things like that, Laura does give you the opportunity to write a letter that says, I did my best to find that information. It happened around the fall of '81, and I really don't remember much else, but it was in the Farmington court or wherever it was, and you provide that information.
And just like Craig said, it is your duty as an applicant to try and remember these things. They say they want it all. That's not in question. So you should be doing everything in your power to remember what the hell happened in your past. But if you're in a position where there's information the state wants, you can't remember all of it, it shows that you didn't knowingly withhold something when you give them as much as you can.
That's right.
That's the difference. If you give them nothing and they find something, that's a harder question to answer. Why isn't it on there? Oh, I completely forgot about it. As opposed to, they asked for 10 things, I gave them 3. I tried my best, doesn't scream I knowingly withheld information from them.
And this gets into, and I think you referenced the gentleman that had the difficulty with the 4,000 plants and the conviction from a prior outside of 10 years. And so we've long since talked about, and it's probably in some earlier shows as well, that just because you had a felony that's greater than 10 years old, we know if it's earlier than 10 years, you can't apply, you're not eligible. If it's greater than 10 years, it doesn't mean you're getting a license, and clearly that happened yesterday. Right. And this is where the follow-up happens. The application doesn't leave you a lot of room to provide a bio about yourself. It doesn't really give you the opportunity to give a narrative. Clearly in phase 2, we have facility plans, we have technology plans, we have staffing plans, we're giving narratives.
You have autonomy to present them in a certain way.
Right, and so this is an area where if you have this criminal history, maybe as a letter on top, a cover letter, that can be included with the application, either as an other or literally on top of that portion of the application, and provide the best narrative you can. And obviously we don't know what was beyond what was talked about at the board hearing. Our advice likely would have been from the onset, let's talk about what's happened since your conviction. Let's raise you up. Let's talk about that community work you've been doing. Let's talk about that charitable work you've been doing. Let's talk about your career and your success and how you basically allowed water under the bridge to go away, but that your passion for the medicine hasn't changed and that you have, and so on. And so maybe that could have helped, maybe it wouldn't have.
Maybe it didn't happen. I mean, let's be real. We don't know what kind of information was presented.
Unfortunately, it didn't seem like they had more information.
Right. So here's moving away from the knowing issue onto the character and fitness issue. Right. What's concerning to me, or what I would have liked to see the board doing next time, is perhaps not just giving their conclusions, but making some sort of argument to the other board members for why they're coming to those conclusions. Without having the full set of data that Laura has in its report for the board to review, we don't know what the narrative was about that issue and why it might be problematic now. We have reactions to them and board members giving their takeaway on it. But, what we ultimately get is a very brief conversation, a quick vote, and not a lot of record to objectively see if we agree with one side or the other.
Yeah, that is very true. And obviously while we're critical of their presumptions, it allows us to be forced to make presumptions too. And, we can only look at our own experiences, knowing how our applications are, knowing our interaction with Laura and the rest of it, seeing deficiency letters and helping people cure those. And, that kind of experience, that data set, we've said every one of these meetings we're learning more and more and more. And it's key is learn from that information and utilize it favorably. One really disconcerting denial yesterday to me was when they had that entity where the 70% owner was deemed to be not qualified. The 30% owner presumably bought out that position or removed him from the corporation, and it was 2 people, I think, that were removed, even though the board only referenced 1, and then I think Chris Jordan jumped in and said it's actually 2. But Laura gave an explanation. Laura actually said this person isn't they're on their own. And for whatever reason, the board members had the assumption, well, if they went out voluntarily and this person from out of state didn't replace that person within their business, they must be still relying upon the non-eligible person. And on one, I don't agree with that conclusion, but allow me to say this. I think that the takeaway to me is that if somebody is removed from your plan due to whatever concern you have to replace them. You have to show that that person's job, that person's role, that person's interaction with the company has been filled by somebody who is eligible or would be deemed to be.
Because or you're allocating more assets than you were going to beforehand.
I mean, we got to see why the person was out, what role they have. But the reality is, in this situation, just talking about that fact, was, to me, that there wasn't an argument left open from what we saw on the record that could have allowed that New York operator to say, I replaced that person with this person.
Right.
We don't know if maybe they were given an employee job versus a role as a vetted operator, because those are two different positions. Maybe that task is taken over by an employee now. But still, the point is you have to provide a narrative that cures that gap that's suddenly created.
Right. And again, we don't know what the rest of the picture was. So maybe there are financial issues or structural issues that call other things into question that just weren't discussed. And again, anyone who gets denied does have an appeal process.
Yes.
Obviously, it's detrimental to getting up and running quickly when you have to wait for an appeal process to go forward. But, assumably that's your opportunity to have a conversation and make an argument about why you shouldn't have been denied. That conversation, those line of questions, digging in deeper to what these evidence actually are, that just isn't occurring at the board level.
Right. And again, once we see some appeals, once we see phase 2, we're going to have a better data set. Well, as you've seen all along, we're going to do our best to continue to provide that information through our Facebook Lives, through our answering questions on Facebook directly, or just calling our office and talking with us. There were a couple of, I think we've done a good job talking about the meeting, and certainly if people have any specific question, feel free to chime in now. James, you were asking, what happens to these laws? The MMFLA and the new rec bill are designed to kind of live side by side a lot the way the caregiver law is going to live with the MMFLA. There'll be some taxation changes and stuff like that, but for the most part, a lot of the way these license types are set up is really going to be on the same foundation as the MMFLA.
Right. It's important to remember, though, we currently have 2 marijuana laws. If a rec bill passes, we will have 3. None of the old laws are going away. We continue to have a patient caregiver system. We continue to have an MMFLA system. And if recreation happens, we'll have a recreation system. Nothing kind of significantly changes about the 2 existing marijuana laws if recreation happens. It's just, what kind of conduct are you engaged in? Are you engaged in medical marijuana conduct? Well, it's either the 2008 law or the 2016 law. Are you engaged in adult use conduct of some kind? Then you're in the new recreational law.
That's right, and certainly there's still a lot of work to be done for that. We appreciate everyone at the coalition and what they've done.
Definitely.
We have, I think next week, a very significant time lapse where on June 5th, the Republican legislature and governor might make a change. We'll see how that plays out. We've heard rumblings on both sides of that. It's kind of on the fence right now either way. But notwithstanding, that is something that we'll always be paying attention to, and hopefully the way that these laws work, quite frankly, is that the MMFLA provides confidence to communities to see that the whole fear-mongering and their whole community isn't falling apart on marijuana, allows them to recognize that having cannabis in their community is something that's a positive and does service their community, and is good for their, opiate reduction and alcohol reduction, and all the other things we know are positive about it. There was some other questions too about, the caregivers and this, I think, erroneous statement about being illegal.
Yeah. So again, this kind of falls into the bucket of making assumptions or what we perceive as assumptions instead of relying on facts. There are some questions about caregiver conduct and what you can be compensated for that I think are fair to call into question. But it's very clear in Section 4 of the Medical Marijuana Act that you can be compensated as a caregiver. Now, compensation as a caregiver, how much compensation, not really a set-in-stone answer to that. But to claim or indicate that caregivers can't make profit might not be the best way to characterize what you can or can't do as a caregiver, to a point where the context probably is going to be a factor. If you are making a little more than the next guy, probably not a problem. If you're making a lot more than the next guy, it might be a huge problem. So, again, there was discussion about that at a board meeting. I think some statements were made that were pretty unsensitive and to what patients and caregivers have to go through that were concerning to me. And then there were also some statements made about a compliant caregiver and assumptions about, only compliant because they knew an inspection was happening. and things that were indicating to me that there's no facts or evidence to support that position. There's bias supporting that position.
Yeah, I mean, in that comment, we know that no matter what that person would have done, the assumption from that particular member would have been they were illegal. I think that this also goes back to some other advice that we've heard and seen from Laura, and that goes to when you have accounts and bank statements where you have deposits that might be not the norm, they might not be with the regularity, they might not be attributable to a specific job. It might be because you as a caregiver had, harvested and sold your, to your patients, and you made your money back and covered your costs and your time, which is totally legal under Michigan Marijuana Act. The fact of the matter is we need to explain those deposits. Mm-hmm. And we've seen from Laura that if they see unusual activity, they need to have that explanation. And this goes back to same as the criminal disclosure. If we see it there, then let's explain it. Mm-hmm. Let's get in front of the problem, not have them ask us about it.
And for all you applicants and future applicants, when you do get, or if you do get some sort of deficiency notice from Laura and they're asking you to explain something, this is one of the only times you can provide an answer in a way that isn't structured in this application. If they're asking about something, it's because they find it to be serious, not because you think it's serious or not. If there's questions about statements on one of the supplemental applicant's accounts, we should provide not only the honest answer, but a reasonable one for what's happening there. And if there isn't one, well, that's probably the reason Lauren has a question about it in the first place. So it's important to take all of this very seriously when disclosures and disclosure problems continue to be the leading cause of application problems right now. There's a significant amount of data that needs to be collected, a significant amount of data that needs to be reviewed, and they're reviewing all that data because it's their job to. Whether we agree that that's data they need or not is really irrelevant. The statute says they need it. Laura says they need it. The board's going to be looking at it. So
yeah, and another question came up talking about amending the laws and allowing caregivers to do nurseries. I think that actually, if you look back at the amendment that occurred in the beginning of the year, there is language now in the grower and the processor rules that do say that a caregiver can actually transfer to a grower or processor seedlings and tissue culture. So they have considered the genetics of caregivers. In fact, you don't even need a secure transporter to make those transfers. The question of what a seedling is and where it turns into a plant in terms of suddenly falling into the counts, those things are going to be very important. But just understand that if you do have solid genetics as a caregiver, you have value with that. Right.
And for all of you commodity. And for all of you caregivers out there, there is a window of time where newly licensed growers can not only take in seeds, tissue cultures, and cuttings, but also the entire plant.
Yeah, hiring you as the
if you're an employee or a member.
Your caregiver card.
Now that's a window that will eventually close, and you'll no longer be allowed to do full adult plants into the system. But you'll always have a method, and this doesn't go away, a method for you to, for profit, I guess, unless profits aren't allowed for caregivers.
No, it actually says, I guess the question Willen asked is, and I'm assuming it's a pseudonym, it says it authorizes the sale or transfer. Mm-hmm. Sale, which means sold for money.
Well, so, it doesn't say profit, so I guess there's room for interpretation.
Right. And so, but again, that falls back into the earlier conversation where the board member wrongfully called caregivers who were earning some money. There's language in the MMRA
right in Section 4
that allows you to have the sale. So, what else does that mean? If you're walking in, you're bartering. There's a transaction that occurs. So, that's what sale is. So, but we covered a lot of topics today. We've gone about 34 minutes, which is around the length of time I think we try to do with our Facebook Lives. Certainly, if you have other questions, feel free to comment on this particular video or reach us at Cannabis Legal Group on Facebook or contact us through cannabislegalgroup.com. We'll do our best to continue to answer it, provide as much information as we can to be the foundation of this market. We look forward to seeing what happens at the next meeting. We'll likely have a Facebook Live in between now and then, and so we'll see you next week, next Friday. So for Craig Aronoff,
Travis Copenhaver.
Thank you very much, and we'll see you all next week. Thanks for everyone for watching. Have a great day. Great weekend. And by the way, go to CannaCon. That is happening this weekend downtown. Our office is sponsoring the Network Mixer this evening. We're one of the sponsors of that. It looks like it should be a great event at St. Andrews. So before we sign off, please engage the industry, get your PhD in the industry. This networking event, this CannaCon.
It's happening right now.
Fantastic information.
Today and tomorrow. So.
Yeah, great information, great vendors. So enjoy your weekend, everybody.
See ya.